You are watching Sailor Today TV, your unmissable dose of vitamin C. Hello friends, starting soon an unmissable live coverage here on Sailor Today TV. You are watching Sailor Today TV, your unmissable dose of vitamin C.
क्या यही प्यार है?
हाँ यही प्यार है।
दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं। क्या यही प्यार है?
हाँ यही प्यार है।
दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं। पहले मैं समझा कुछ और वजह इन बातों की, लेकिन अब जाना कहाँ नींद गई मेरी रातों की। जागता रहता हूँ मैं भी, चांद निकलता नहीं। दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं।
कैसे भूलूंगी, तू याद हमेशा आएगा। तेरे जाने से जीना मुश्किल हो जाएगा। हो अब कुछ भी हो, दिल पे कोई जोर तो चलता नहीं। दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं।
क्या यही प्यार है?
हाँ यही प्यार है। दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं।
क्या यही प्यार है?
हाँ यही प्यार है।
दिल तेरे बिन कहीं लगता नहीं, वक्त गुजरता नहीं।
John, welcome to the Bangalore chapter. Is prepared for the students and the faculty of the Indian Maritime University. So, the impact of passage planning on seaworthiness and carriage of goods. So, this particular part, I am going to talk to you what is passage planning, the need for passage planning, which may be child's play for you, but for a student or for the lecturer at the IMU University, it is different. Then the other particular part that I'm going to introduce to you is the aspect of seaworthiness. What is seaworthiness? The seaworthiness that you think or I think may be different, but what's in the textbook. The other particular part is of the carriage of goods by sea. That is the Hague rules, Hague-Bisbee rules. And then I'm coming on to this particular case law of the CMA CGM Libra case. And then how did it move on into court and what are the lessons to be learned? So the first particular part is, what is passage planning? Passage planning is a navigational tool used for the safe and efficient transit used by the master and the crew to navigate a ship safely and efficiently from point A to point B. Not only that, it has to comply to the international, national, local rules and regulations. So, those of you who are familiar with the passage plan, in the sense what you call, there are 4 steps of passage planning. Just want you to recollect. The first is appraisal, correct? Good. Second particular part is planning. Third particular part is the execution and the monitoring. I don't want to go to you in detail because all of you are very, very familiar with this. It's an every day event, those for the sailing masters. So the appraisal starts with the condition of the ship, the stability of the ship at all different stages, the weather. The third particular part is executing the plan and taking action as per the prevailing circumstances and conditions. And the last monitoring is the progress. You are marking the progress of the vessel against the prepared and the approved plan. So where does this all come from? It comes from SOLAS Chapter 5, Regulations 34, under safe navigation and avoidance of dangerous situations. So then we have the guidelines for voyage planning, IMO Resolution 893, which was passed on the 25th of November 1999. Where did that start from? That happened because of Marine Safety Committee review of the code of safe carriage of irradiated nuclear fuel, plutonium and high-level radioactive waste in flasks and on board ships, rather called the IMF code. So what happened was actually this passage planning was meant for this particular vessels which are carrying nuclear fuels, and you can just imagine a calamity that if you have to have a collision. So then they realized, in the sense it's not only one vessel, the other vessel too requires a passage planning. So it's not only the nuclear carrying fuel. So they brought in this passage planning for all particular vessels, and that's how you got this IMO Resolution 893 bracket 21. And then it also comes in STCW Chapter 8 Part 2. It's basically a plan, holistic in nature, which does identification of hazards to the event. To be considered object also on board is proficient at the usage of electronic chart display and the information system. Particularly the judge has particularly mentioned about this particular incident about the marking of the no-go areas and the safety contours and depths, and also the effect of weather. So comparatively, we take it for granted that whether the weather conditions we expect favorable weather always, but it need not be. As the case what has happened today in China, where the sandstorms have just taken cities by glue. So what is the need for passage planning? So it aids in critical decision making. It assists the master, the officer on board, to take critical decisions in a safe and efficient manner. Rather, it is a tool, or rather it's a risk assessment of this particular passage. And it promotes safety and efficiency in navigation. And you know fully well that today we have hell of a lot of diversity, may it be in gender diversity, whether it's in ESG or whether in different cultural barriers. So it cuts across language barriers, cultural barriers. So ultimately, it is this particular tool you have to deliver. So the risk assessment of the passage plan is understood by all, irrespective of what the nationality of the officers on watch are. It helps in faster turnaround of the vessel, makes it an incident-free voyage, and ultimately, like what is the IMO theme? It's safe ships and clean ships, clean seas. So it goes in for cleaner seas and cleaner air, brings in productivity factors, like, ultimately, like, if you have to take the GDP of a nation, I mean, we talk about the CIF, how much is the insurance, I mean, the logistics factor, I mean, in the sense what you call, like, in India, it's high, I mean, the developed and the developing countries. So we would like to have a faster turnaround of the trade, and then reduces carbon footprint of carriage. I mean, in the sense we all know about the decarbonization of ships. I mean, like, we're looking at 2030. I mean, the sustainable change factor, how we will be bringing down the temperature to 1.5 degrees lesser by 2050, and perhaps have a total green economy by 2070. So this, with this passage plan aspects, let's go to the aspect of seaworthiness. Seaworthiness has got 4 contractual relationships. One is, what is seaworthiness in a marine insurance voyage policy? The assured warrants that the vessel is seaworthy. Yeah, I mean, it's an implied warranty that, like, what we call, the owner will make the vessel seaworthy. That's when it comes to marine insurance. The second particular part is, a carrier of the goods by sea owes a duty to a shipper of cargo that the vessel is seaworthy at the start of the voyage. I mean, rather, your back part of the bill of lading. I mean, this is bill of lading. Nobody is going to give you a cargo if your vessel is not going to be seaworthy. So that's your relationship with the cargo interest. The third particular part is, a shipper owner warrants that to a charterer that vessel under charter is seaworthy. So I mean, in the charter party obligations, I mean, in the sense contract of carriage in a charter party obligation. The fourth one of seaworthiness is, a shipbuilder warrants that the vessel under construction will be seaworthy. It's obvious. I mean, when we buy a car, I mean, we want the car or the vehicle to be roadworthy. So the same thing happens for a particular contract between a building ship. This has been defined long time ago, as way back in 1900, and the origin of it takes place. I mean, you must have heard of a treatise on the where actually this particular thing has been defined, and that is called a prudent owner. What is a prudent owner? Your own car. Will you, and if you know that the brakes are not working, will you be taking that on the road or on a walk, on a journey or across the Ghats? So I mean, your conscience will tell you it's not safe for me to put the vehicle on the So what does this particular prudent owner test come from? In this particular case, I mean, I would rather, because it's a matter of 45 minutes, I'm covering the lecture, but I mean, I would like you to go back and check on this. In November 1903, a ship loaded cotton from the port of Wilmington to Bremen in 1903 by the name of, the ship's name was Tolosa. And I mean, in the sense, what you call like a Blue Star Line, and McFadden was the cargo interest. And there, what happened is that, like, was barge, or rather of the vessel, did not hold good, and this was contested, and ultimately it was ruled against the owners, and that is how the first part is called the Muncaster Castle incident, and this is the Riverstone Meat Company versus Lancashire. This happened in 1961, and what was it about? The cargo was about 150 cases of ox tongue. I mean, like, you are all familiar with oxtail soup or oxtail tongue. damage arising or resulting from act, neglect or default of the master, mariner, pilot or the servants of the carrier in the navigation, in the management of the ship. This whole particular thing is on one side, like, the one party says that, okay, you have not exercised due diligence, other particular persons, I have a right as per the Article 4A. So one particular party is using Article 3 and the other one is using Article 4. So now, just to brush up, the other aspect of the rule is the general average. And general average are under York and Capt rules. And 1994, they keep changing. I mean, in the sense, what you call it. So, if you remember your master's oral, I mean, you would have known the definition of general average. But I just want to, the definition of York and Capt rules of 1994, Rule A. There is a general average act when and only when an extraordinary sacrifice or expenditure is intentionally made or incurred for the common safety for the purpose of preserving from peril the property involved in a common maritime adventure. So what it requires is it has to be an extraordinary sacrifice. It has to be voluntary. The third particular part, it has to be reasonable. And the other particular part, it has to be imperiled with common adventure. So, I mean, York and Capt rules comes under two parts. One is the letter rules, that is called Rule A to G. And the other one is called the numbered York and Capt rules, Rule 1 to Rule 23. So, like comparatively, in the slide I put understanding general average because I told you that it was also to the students. So that comparatively how you share or how you spread the risk in the event of a particular part, like in an average bond. And so I will not be covering understanding general average, but I'll take it up in the question and answer session. But what is the difference in this particular part of general average? I mean, just because owner declares general average, I mean, are you bound to give your contribution? No, there is a particular defense to this. Rights to contribution in general average shall not be affected, though the event which give rise to the exercise or expenditure may have been done due to the fault of one of the parties to the common maritime adventure, but this shall not prejudice any remedies or defences which may be open against or to that party in respect of such a fault. So in the event that there is a particular fault of one of the parties, I mean, in the sense what you call it, then I may not be obliged to contribute to the so now this particular whole thing is the aspect of marine insurance. I mean, marine insurance is comparatively there to make sure that you come back into the same position Consequently, marine insurance is essential if the companies and their ships involved with this trade and the goods themselves are to be protected from the persistent risk and liabilities that are inherent with in the best sense, what happened in the Suez Canal just about the March of 2020 or so. So the York and Capt rules also have a particular interpretation. In the adjustment of general average, the following rule shall apply to the exclusion of any law and practice. So in the general average, the lettered York and Capt rules, that is rules A to G, will overrule the numbered York and Capt rules. And there is something called clause paramount, I mean, in the sense, which was one of the favorite questions which you have to answer. So, in no case shall there be allowance for sacrifice or expenditure unless reasonably made or incurred. So, I mean, with this, background of impact of what is passage planning, the covering of Hague-Bisbee rules and the general average, I come to the the case law, the case study. So this is the vessel Libra. She had an IMO number of 9399193. It was a Maltese flag, and she had a gross tonnage of 131,332. Bill in 2009, she had a dead weight of 131,292. She was a container ship, and she was having a capacity of 11,356 TEUs, and she was laden with 5,983 containers. And she was on a passage from Germany to Hong Kong. And I mean, like, you know, in the PowerPoint, you have this particular chart 3449. Unfortunately, friends, I had that chart with me. I carried it to Chennai, but it is in the sense. Was a preliminary notice, and 10. The chart or the thing, I mean, like, those of you who would like to have a quick look at the chart, or rather you can just turn it, but I don't know about the camera, will it? So anyway, I mean, in the sense what you call, like, you know, the chart is, the passage is very long, I mean, in the sense what you call, and I understand, I spoke to a lot of my friends who are sailing with container ships, and they say that traffic density is quite high in this particular area, and then, like, you know, the ship was also going from Xiamen to Hong Kong, where you have a lot of time pressures to keep up the ETA. I mean, like, excuse me, I've given up sailing for a long time, but I mean, it says you should be doing better. So, but then they said that there could be various reasons, I mean, in the sense. So what happened in this particular Admiralty Court of First Instance? So the Admiralty Court of First Instance, the ship owners, of course, had moved the court. So the thing is that, like, you know, they went on the aspect of what do you call the Hague-Bisbee Rules, Article 4(2)(a). So the ship owner's assertion was not accepted; it was ruled out, and the judge at the first instance mentioned that it was an error of navigation. Okay. Second particular part they mentioned was absence of an adequate passage plan, which was the cause to the grounding exercise. And it was a breach to exercise due diligence prior to and at the time of the commencement of voyage. So comparatively, like, you know, I mean, in the sense, this is what you call, it is facts, where even the master gave what you call his evidence, and it has been recorded. I mean, like, you know, that and based on that, this particular judge gave that. So ultimately, it was ruled that the breach to exercise due diligence prior to and at the time of commencement of the voyage, I mean, did not make the vessel seaworthy, and the cargo interests not liable to contribute. I mean, in the sense, what you call, like, you know, that 800,000 was not, like, you know, was not to be paid. for which the shipowner had gone to the court. So automatically what happens when you lose in the first instance, you always go to the court of appeal. And that particular part is not facts, basically a question of law. I mean, in a sense, what you call. And this was a bench of 3 judges. I mean, like, those of you that the question and answer session, I mean, I brought both the judgments. I mean, this is the judgment of the Supreme Court, and the other one is the Court of Appeal. Both are voluminous. I mean, almost about 70 pages. So here it's a bench of 3 judges, and there were 2 questions on the aspect of law. The first one was, does a defective passage plan render a ship unseaworthy for the purpose of Article 3, Rule 1 of the Hague-Bisbee rules? I mean, in the sense what you call, like, the Hague-Bisbee rules are here. So this is the act. I mean, in the sense what you call, like, each particular part you have to read it out. I mean, in the sense question answers will. So one is, does a defective passage plan render a ship unseaworthy for the purpose of Article 3, Rule 1 of the Hague-Bisbee rule? Right? Second particular part is, can the actions of a shipmaster or crew, which are carried out in their capacity as navigators, be treated as performance by the ship owner of its duty as carrier to exercise due diligence to make the ship seaworthy under Article 3, Rule 1 of the Hague Rules? I mean, in the sense, all the 3 judges said the appeal fails, case was dismissed, because, I mean, I spoke to you about the prudent, the owners took a stand that, like, it is the shipmaster and crew. But here what the thing was, it is the ship owner as a duty as a carrier. I mean, in the sense, I gave you that Moncaster Castle example, fitter. I mean, so automatically, like, the duty, this thing becomes on the exercising of due diligence comes on the ship owner. So the appeal failed and the case was dismissed. I mean, rather, that means it still remained on the 800,000 GA interest. I mean, the respondents. I mean, in the sense. So, and it was also an unanimous judgment. So, I mean, in the sense, at the court of instance, the claim failed, and at the court of appeal, the claim failed. Then ultimately, like, it is the Supreme Court, and the matter goes to the Supreme Court. I mean, in the sense, just imagine that the incident took place on 18th of May 2011. Okay, 2011. And then ultimately, like, the Supreme Court of UK gave its judgment on the 10th of November 2021. So actually, like, so it has taken practically 10 years also for the, this thing to go through the process of getting ultimate, like, once it's a Supreme Court part, judges make law. So automatically this was a bench of 5 Supreme Court judges, and they uphold the judgment of the Admiralty judge at the first instance. I mean, basically those are all the facts. And also the Court of Appeals. I mean, the judges of the appeals court were three. And what was the question? Vessel likely to be unseaworthy if she begins a voyage with a defective passage plan. I read out to you the definition, prudent owner, I mean, in the sense, at the beginning of the voyage. So at the beginning of the voyage, this particular passage plan, I mean, in the sense, was comparatively what happened, but the passage plan was there. It was not that, but the master deviated from the passage plan and went into shallow waters. That's what which led him to go aground. I mean, comparatively, I mean, in the sense, and this particular notice was that preliminary notice which was given in the December 2010 by the UK Hydrographic Office. So comparatively, it had not been marked, it had been not taken very seriously. So, but at the same time, had it been like, marked and the no-go areas and all that was done, perhaps this could have been avoided. I mean, comparatively, like, it's easier for us now today to sit like armchairs, masters and discuss. But ultimately, like, what's the purpose of the CMMI lectures or any particular, that, like, we would like to prevent any further incidents or like learn from each other's experience. That's this. So the first particular part is vessel likely to be unseaworthy if she begins a voyage with a defective passage plan. And the other particular part is Article 4, Rule 2, that exception. Error in navigation is not a defense. So, I mean, in the sense, a carrier cannot escape its Article 3, Rule 1 obligations by delegating them to its servants or agents. And the other particular part is the carrier is responsible for causative failure by crew to exercise due diligence. So, I mean, in the sense, it is the responsibility of the carrier comparatively. Okay, so this is the sum and substance. Of course, I mean, this is points just picked up from a 70-page judgment. So, I mean, comparatively, we cannot keep up to the entire, to keep it interesting and to have to make sure that the topic doesn't lose its interest. And finally, summing up, friends, now you have to understand the legal principles of due diligence. What is due diligence? Duty of care. I mean, in the sense, when I drive, my car, I have a duty of diligence. I have a reasonable responsibility. I mean, duty to care another person's vehicle, another person's life, or other thing. So, legal principles of due diligence and seaworthiness has to be applied to passage planning. So, passage planning cannot be taken lightly. Error in passage planning prior to the commencement cannot be characterized as an error in navigation. To all the sailing masters, I mean, appeal to you is error in passage planning prior to the commencement cannot be characterized as an error in navigation. The navigation doesn't start at that particular moment of time. The navigation, like when does this navigation start is also another thing, which is also like, whether after casting off or whether what you call pilot on board or other thing, that's still debatable and arbitrary or like, after the pilot. But this particular part that your passage plan is not part of navigation, it's your tool rather. Importance to application of temporary and preliminary notices to mariners. That, I mean, it's stressed upon. Today, I think, with egg disc and with show, support, I mean, that particular part will be taken care of. But at the same time, it doesn't absolve you from the responsibility that make sure that, whether even this particular, any technical or electronic glitch has taken place, just to make sure, double check. I mean, that you are up to date with the latest notices to mariners, and then cargo interest to give careful consideration to GA contribution. Now, I mean, I mentioned to you that, just because somebody is asking you for a GA, I mean, you declare GA, I mean, so automatically the cargo interest will be taking up careful consideration to GA contribution. And ever since this happened, I mean, almost as US dollars $116 million claims related to passage planning as per international group of P&I clubs since Admiralty Coast decision to March of 2022. I mean, if you have to take this particular part, so $116 million of claims have come in as per the international group clubs. So ultimately, at the same time as sailing masters, what we need to do at any particular stages, we need to step up evidence collection during a casualty investigation and GA declaration. So ultimately, we can do that, I mean, as masters, or that is within our purview, because that particular evidence can be very crucial in helping the ship owners who employ us, I mean, to do their best in defending a particular claim. So with this, I mean, I would like to hand over the proceedings to the Chairman, and if there are any questions and answers, I would like to answer with my limited knowledge. Thank you, Chairman.
Thank you, Captain John, for enlightening talk. Any questions from the audience?
Yes, we lost the case. And what happens to all the guys who paid up? When they will now...
They are not a party to the suit, no?
No, I know. They could now have to pay.
No, you'll have to see, the thing is, I mean, those particular people, that's a different question. It is this particular people who challenged. So I mean, like that becomes a separate case. I mean, like I feel they'll have to start their whole proceedings once again.
They would do that.
I don't know. I'm not the competent authority to speak on that particular subject. But all I can tell you is that, like in this particular suit, I mean, this A basis B. I mean, rather the parties are these. What do you call it? It's basically not. It's not also the shipping companies per se. It is Ellis 1974 and other appellate basis alliance. I mean, ultimately, it's the insurance companies which are fighting it out. So the thing is, what do you call? If the matter was between A and B, C cannot come in and take this thing. C will have to go separately. That is how the law of evidence or this thing is.
Separation. I think they didn't cause others to come.
No, see, the thing is, this has come out only in the month of what do you call it? This has come out in the month of November. So it's just 7 months ago. So I mean, like we don't know the what do you call the results that have taken place in the last 7 months. But I have not read anything that that the others are going to come back on it. But that's happened. I mean, it's once you have once you have entered a contract, it is mutual. No? I mean, it's offer, acceptance. I mean, like once you have signed the average bond, you have given that money to the owner. So I don't think that
once it is settled, it is very unlikely that they can go back and claim.
that's what happened.
This was also part of what I wanted to ask. What happened to the money that has been paid?
On the question and answers, I think we can. What do you think? Because then we can be more informal.
Okay.
Okay, that's better, I think.